Okay, so guys, for the record, please announce yourselves. State.
Anna Eady, E-A-D-Y, for Mr. Wiggins.
Nathaniel Meunier spelled M-U-N-I-E-R, also for the defense.
So hold on, before you get into anything, State, you wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked those jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO, since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number.
So in one day,
So yesterday, he attempted 28 calls to the complainant's phone.
So, Judge, I'm going to preface this conversation with, Miss Eady texted me about 10 minutes ago, so I came up on short notice on this. But my understanding is that there's no longer a protective order in effect because it's been long enough.
there's a court order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
Well, he is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken.
I have ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, which would be a separate criminal proceeding. At the same time, for Miss Eady talked to me today, it sounds like that the court was going to order ag-seg in the jail, so the formal
The only way that we can revoke phone privileges on someone is ag-seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond. Thus, no crime has taken place. And third to that, Judge, if he's to move to ag-seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies. And
The only way, but okay, I understand your plight.
Yes, Judge.
But there are other remedies for you to be able to communicate. Letters, in person. But the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to be called, including our office as well as his felony attorneys. Letters to the jail are notoriously slow. A letter to my mother, who lives in the same city, takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag-seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not prevent
Judge,
phone calls.
This would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights. Right, self-incrimination because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. You will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms there.
It's not about me, Judge. It's about felony court is a serious issue. But that's the.
Why are you worried about felony court?
Because that's why he's in, Judge. Then
That's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is...
There are other means for you guys to participate, but I've ordered you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry, I missed the last statement. I'm
The
sorry.
only way that I can prevent him from making 300 phone calls is to put him
So
in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it on your cell phone. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not going to say, can you please block your number so he can't call you?
The least restrictive means, Judge. Strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have you guys before, and I had admonished him before. Please don't. We put you in seg last time. You were there a month. You came here begging and pleading. I'm not going to do it. I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do. But now back into accent.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I have them. I just have to get I have to do the forms or get them up with the forms. Yeah.
Okay, so let's set up a formal hearing because I don't want. You're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
I'm trying to think of the last time that I got killed. It's if I mean, it could be tomorrow, it'll be a few days. So, I don't know if we want to set off next Monday or something like that, but I think I should have all by then. This was just a plan for that. Actually, connected to such questions.
And if we can keep him in normal population so that we can visit him, as does his family counsel, and they can
Wiggins, I'm going to have you sign an affidavit from today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of AGSEG. Do you understand? No. Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules. I said real.
Yeah.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand?
Yeah.
Okay, so you want to set up for Monday?
Sure.
Okay.
I mean,
So just get it as soon as you can, get it to them. We'll have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that it truly have no least restrictive means than to deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
He in the last time he used someone else's SPIN number to make the phone calls.
That was last.
So,
Yeah.
well, we'll see this time. I don't know. Okay. All right.
Just so we saw the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. Do you understand?
Sure.
Okay. Thank you, Judge.
Thank you.
Thanks, Ed. So much. Good morning.
Hi, Mr. Arroyo, on your influence document.
Okay.
We're here for a bail order. All right.
And for what it's worth, you don't really have to approach. The only time is if you need something. Then just for, it's a high bond, huh?
It is, Your Honor. We are requesting a PR bond.
Say it again.
We are requesting a PR bond, so.
Good morning, Mr. Arroyo.
Sir.
How's jail? Fun?
No, sir.
So, February, you have a terroristic threat with us of a family or household member, and now you've picked up an evading arrest in a motor vehicle. While you're on bond for this case, you pick up a serious third-degree felon. What happened in a terroristic threat?
Terroristic threat, Your Honor?
The terroristic threat in our case.
In our case, on February 3rd, 2025, an officer responded to a weapons disturbance at a residence in Harris County, Texas. The officer met with a witness who stated that her granddaughter's boyfriend, the defendant, was upstairs in the house with a gun. The witness stated there were 5 other people in the residence, and everyone exited the residence safely except for the defendant. The witness who stated she had been dating the defendant for 3 years and broken up with him hours before, and the defendant left the residence. When possessed the defendant wanted to retrieve some items, and the defendant said no. The defendant came back to the residence, and the complaining witness refused to let him in. Short time later, the defendant sent complaining witness a picture of him inside her vehicle, pointing a handgun at her bedroom window. The complaining witness saw a laser through her bedroom window, which she knew was attached to a handgun that he owned. The defendant threatened to kick her door down and make forced entry into her home. The complaining witness still refused, and the defendant began hitting the windows around the house and screaming the complaining witness's name. The complaining witness called 911 and went inside a different bed.
Something out of a movie, like a horror movie.
A second witness, the uncle, led the defendant inside the residence because he was unaware of the break-in. The defendant went straight into his room. The officers tried to make contact with the defendant but were unsuccessful. The defendant was identified by a photo and date birth.
So tell me what happened now in the police, in the evading.
Yes, Your Honor. On April 2nd, 2025, a law enforcement officer was dispatched to a vehicle in reference to a discharge of a firearm. While searching the neighborhood, the law enforcement officer made contact with the witness, who advised that the driver was a Hispanic male with light bushy hair, and the vehicle had a plastic wrapping around the rear window with one laminated tail lamp. The law enforcement officer continued to search the neighborhood and observed a vehicle that matched the description. The law enforcement officer made a U-turn and pursued the vehicle. As the law enforcement officer approached the vehicle, the driver accelerated speed and disregarded a stop sign.
Tell me they found a gun.
The law enforcement officer do not have that vehicle. And the law enforcement officer initiated lights and sirens to stop the vehicle, failed to stop, accelerated speed and disregarded multiple stop signs for approximately 3 minutes and around 1.5 miles of roadway, reaching a speed of 62 miles an hour. There were multiple areas the defendant could safely stop, and the defendant stated he evaded because he believes he had an open warrant for family violence. I believe
In warrant status? Do we know?
if this wasn't warrant status, Your Honor, that means
It was a 2B, Your Honor. It wasn't, it was a 2B that was filed. It wasn't so I think they're speaking about the terroristic threat family violence in our case. And it was filed as a 2B. He never was arrested on it or didn't record it.
You know, Mr. Arroyo, you need to think that in this world, when you go to jail, you now know you have no one that's going to pony up money to get you out. So when you go to jail on charges, you are stuck unless someone's right. Since January, you've had an unlawful restraint, an assault of a family member. Now you have these 2 open cases. Why would we continue to give PR bonds?
And if I may, Your Honor, the 2 previous cases, the unlawful restraint and the assault family member, the file date was back in 2023. He had it set for a jury trial and it was dismissed. He never bond forfeited.
You represent him on this case?
I did not. I was just appointed today to him.
Okay.
But I'm just looking at the procedural posture of the case. He does not appear to be a flight risk of any kind. He took those cases and...
Well, I mean, he's evading capture now with the police, you know? Something's going on with you, man. I don't know what's going on, but who do you have in your life? Who's around to give mom, dad, who do you have? You got a son? What? You're a baby yourself. I mean, do you live with mom?
I live with my mom.
Well, that's what I'm asking. Who do you live with?
Yeah, I live with mom.
Do you actually live there, or are you out on the street all the time?
No, I actually do live there. I stay there and I take my sisters to school in the morning and pick them up after school. And I work and I take care of my son every day that I can when I'm not working. And he sleeps over if I'm not going to work the next day. That's all I'm really doing. But
In the last couple months, you've had 4 charges. What do we need to do to ensure you don't pick up a 5th?
He is now living with his mother. It sounds like before he was staying with the complainant. So the change in location is going to be helpful, certainly. He now has employment. He works at Cosmic Air.
Let's do this. If you can, is mom here? No.
I don't believe
No,
so.
So let's do this. If you can verify that she will actually take him, because I'm not giving you a PR bond or even a bond reduction for you to just go out on the street.
Sir.
If I let you out, I'm putting you under very strict rules. No dope, no alcohol, and I'm going to test you like crazy. Does he have a license? You're not allowed to drive. I don't care what you got to do. I don't care about your little brother having to go somewhere or your son. If you don't have a license and you don't have car insurance, then no driving. That is a bond condition. I'm going to have you sign an affidavit promising me if I find that you do, I can have a contempt hearing an additional 6 months.
Sure.
But I'm not letting you out unless you have a stable place to go to, because I don't want you out on the street. Nothing good. And I'm giving you a curfew as well. You understand?
Sir.
I'm going to put a monitor so I know where you are at all times, and then we'll talk. But first things first, not to the street. If you can verify that he's got a place, then let's talk. And I'm happy to do something.
Thank you.
Yes, ma'am. Yes. Good morning, Mr. Bustamante.
Good morning.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You now also have an immigration detainer. I will tell you that when you show up to court, good things happen. This doesn't have to happen. But when you continue to miss court, this is what happens. You ever pick up another charge, come to court. It's not a bad thing. You understand? Now you will end up with a conviction on your record. This DWI will go on your record. It will be there for the rest of your life. If you ever get into a car and drive and you have the smell of anything funky, it's probably not going to go well for you. So I would never, even if you had a sip of alcohol, get into a car and drive. After today, you will now be facing a minimum of 30 days in jail for any new cases that you pick up. You're giving up the right to a trial, the right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, this will go on your record. You can never take it off. Is this what you want to do?
Yes, sir.
How do you plead to the offense, guilty or not guilty?
Guilty.
I'm going to find you guilty. I'm going to sentence you to 30 days in jail. I'll give you credit for the 90 days, the 19 days that you've done. I'm now going to suspend your license for 90 days. Do not drive until you get a license. Good luck to you, sir. Is your guy here?
Yes, sir.
Bring him up.
No, not at all. We have a disconnect on the reinstatement fee. It's a court requiring the reinstatement fee. I was told.
I'm not going to. I'm going to admonish him.
Oh yeah, okay, cool.
And-
Mr. Farfugge, yes, we.
You know,
yeah,
I was going to grant it regardless.
Okay, cool. Okay, it was a disconnect that he came to us. Come over here, Mr. Farfugge.
Oh, yeah.
He's already at PTI.
Okay, great. He already has an interlock, right?
Yes, sir.
Okay, so you need to understand a couple things, that this license right here is on my name. You are only allowed to drive a car that has an interlock on it. This doesn't give you an open license to drive any car. Only ones that have an interlock on it. Do you understand?
Yes, sir.
You also need to pay that reinstatement fee. If you do not pay the reinstatement fee, this is only good for 30 something days, perhaps 45 days. You have to get in full compliance with DPS, and then they will extend this for the full life of the suspension, which is 90 days. If you don't pay the reinstatement fee, probably after 30, 45 days, this is not going to be valid, not worth of anything. Do you understand? So I would probably pay the reinstatement fee as soon as you can. Okay, done.
Thank you, Your Honor.
All right.
Have a seat, Mr. Fleischer. You're gonna bring up. Thank you.
Cheers. What's new?
I've got a new case today, Mr. Romero Bennett.
Okay. And get her.
I believe he has, and
Okay.
and so I talked to pretrial. He got tested already today. I know he's kind of told you he's on oxycodone, which he is prescribed, and so he wanted me to at least present the prescription
I
information.
believe that they're still prescribing it. You're telling me they still prescribe Oxy?
I mean,
They went bankrupt, didn't they?
I don't know about that.
Yes. Yes. The pharmaceutical company that makes that OxyContin they went bankrupt. They got sued. They declared bankruptcy. I guess let me see what you got. I'm telling you, I don't know. Maybe I know that they went bankrupt. How many pills did he actually get? Let me go with this. I cannot believe that they would prescribe this many. This is like an app. So that's it's like this is freaking this is like begging someone to get addicted to this. This is fucking nuts, man. These people. I'm not giving you an open ticket to use that, which is it's a literal death sentence. The problem is, Mr. Bennett, and I don't know if you realize this, but I can't tell you how many friends I've had that have died because what you do is you build up a powerful addiction to this shisa, and what happens is you keep taking, you put your lungs to sleep because of how powerful this thing. The addiction is so powerful that people convulse, trying to get off. Seize.
I brought it just because it was in my system, just so you don't think I'm abusing it. I'm pretty sure my levels are down on what was in my system or on the 4th.
I'm not going to ding you on it now, but I want it to stop. Sure. And I'm not going to continue to let you use. So
she told me since the 4th.
Great. I don't want you to. I'm still going to test you for the foreseeable future. If I know that you're done and you're not using, then I'm happy to modify it. But I want to know that you're not using. And this stuff is so powerful that I'm scared to just take off and not test, right? So I'd like to do it for some time. If he's clean for a while, then I'm happy to take off. But I just don't want you to die. That's all I want, you know, or you take someone else on the way, you know, you just can't, it's so powerful. I can't believe that they would prescribe that much, that many, he tests today.
Yes, Judge.
And?
So the THC and oxycodone.
Okay. We need to figure out when it's going to stop. I'd like to know how many are left, you know, so we can build a plan to when I know it's going to stop. I'm not going to continue to let you use. Like if I see it in 2 weeks, I'm going to have a problem with it. I'm going to tell you now. So I just be safe. That's all I'm asking you to do, you know? All right. We'll reset you. I'm going to test them next week at some point, and then we'll see how it goes.
Judge, we're still there Monday, Thursday.
What do you want, Maverick? I want to test them at least once a week.
Once a week is fine. So I don't know what days you like to do.
Well, I'm going to do it random. That way he doesn't know, because if he knows, he can prepare. So that's why. It's at some point next week, we'll call him to test. Okay, just be ready. Don't use, man. Don't. I'm giving you the opportunity now for you to stop on your own. Do you understand, Mr. Penn? All right, man. Good luck. Okay, thanks.
After 300 phone calls, Judge Fleischer finally snapped, and what he said shocked the entire courtroom. The room was silent as the judge leaned forward. The defendant stood there, waiting for mercy, but mercy was not coming today. Judge Fleischer looked straight at him and said, 300 calls later, and you still think you deserve freedom? Gasps filled the courtroom. The judge continued, reminding everyone how each call violated court orders. Rules were broken. Warnings were ignored. The judge's voice grew louder. This court gave you chances. You wasted every single one. The defendant lowered his head. There were no excuses left. Judge Fleischer slammed the gavel. The freedom is earned, not demanded. And in that moment, the decision was final.